The California Residential Purchase Agreement form is the cornerstone of every successful real estate transaction in the state of California. In this training video, we will review how to properly complete and use the RPA form step by step to better serve and protect yourself and your clients. This training is not intended to be a substitute for the advice of your broker, nor that of your attorney. We will cover paragraphs 11 and 12. Our instructor for this video is Kevin Burke. Let's get started.
So let's talk about paragraph number 11. I like paragraph number 11. I think it's probably, with the exception of purchase price and escrow and title, I think it is probably the most rewritten paragraph in our contract, and I think it is the poorest done. And I'll tell you why. So condition of property has to do, this is in the RPA, this is in the agreement between the buyer and the seller. And so the attorney spent a long time putting together paragraph number 11, and we're going to talk about it in detail. And with all the language that's in there and all the lawyers that are writing this stuff and all the tests and legal challenges that it has survived, and I still see agents writing in counteroffers, properties being sold in as-is condition. And so, you know, the argument goes both ways, whether or not you just rewrote paragraph number 11. But I think it's because there's not a good understanding of what sales of real property in California really is. So, for example, and I'm telling you, but I've got people I talk to. It's like talking to lawn furniture, but it's like I say that with love and affection, but really, the sales of real property in California are in their present as-is physical condition, no obligation by the seller to do any repairs. So a lot of times when I see that counteroffer that says property is being sold in as-is condition, what they're really meaning to say is that the seller's not going to do any repairs. So my advice would be to say that. Say what you mean. The seller's not going to do any repairs is different than you saying property's being sold in an as-is condition. And maybe that as-is is just kind of a cool little word that we learned, and now we want to use it in a sentence, but I would resist the temptation to do that. So I don't want to rewrite paragraph number 11. Smarter people than me have put this paragraph together. It has survived the test of time, the test of legal challenges, and whatever language I write, I'm not interested in paying all the money to make that also, survive that challenge. So that being said, okay, I'm going to pull up my annotator here because I do like to annotate things. I'm going to move myself out of the way. Let's take a look at where we are. We are talking about paragraph number 11, condition of the property, unless otherwise agreed in writing. So unless you do something different, all right, and part of that different, we're going to talk about that, is going to be our request for repairs. Okay, so that'll be something different. So again, no duty by the seller to do any work on a property, all right, but they can contractually agree to do work. So, and we're not talking about that as is thing, right? We're talking about if the buyer submits a request for repairs and the seller agrees to it, now the seller is contractually bound to do that, not statutorily bound. The statute says sales of real property are the way they are. Seller still has a duty to disclose what they knew or should have known. And so sometimes we hide behind that language that says we're selling the property as is condition. Buyer beware. Buyer go figure out whatever they want to do. That's not how the law works. And you can use those catchy little cliches and stuff like that, but we're going to have a problem because you know what? You're essentially giving bad legal advice, and we don't want to do that. Okay, so unless otherwise agreed in writing is what it says. It says on the face of things, number one, the property is sold as is in its present physical condition as of the date and time of acceptance, and B, subject to buyer's investigation rights, okay? And then little II, the property, including pool, spa, landscaping grounds, is to be maintained. So I want to talk about that in a second. Let me finish up what we're talking about up here. So the buyer still has the right to investigate the property. And please, I would counsel against prohibiting a buyer from investigating the property, okay? Even if the time for, even if they've removed their contingency and then they want to come back and do an investigation, hey, let them do it, right? But they've already removed their contingency. So I think that we need to understand that contractually they're bound at that point not to, have any requests that they can make. Okay. So, all right. So the property, including, so this little II is pretty important because it says the pool, the spa, the landscaping, the grounds is to be maintained in substantially the same condition as of on the date of acceptance. And later on, we're going to see how powerful that is, because when we get back to that final verification of condition, and that part of that paragraph is that the property is substantially the same. So I always say same or similar condition as it was on the date of acceptance. So when the buyer buys the property and the property is it's a 3-bedroom, and we go to close it and now it's only a 2-bedroom, that's not going to be the same or substantially the same condition. But so this is going to be important, because this is the final walkthrough is not a contingency of the transaction, but the buyer may have some problems with the seller doing adjustments to the property. And then we're going to look at III, all debris and personal property. And this comes up a lot. The seller left a bunch of trash. All debris and personal property not included in the sale shall be removed by close of escrow. So, and when, so you and I both know it's right up until the day it closes, right up until the minute it closes, and there's still stuff on the property. The seller has agreed contractually to remove it, and so they're going to be bound by that. And of course, it may take a court of law to enforce it, but at the end of the day, that's what the contract says. So people call me and they say, where's the part that says that the seller's got to clean the place up? Well, there is nothing that says they have to clean it up. There is something that says that they'll remove debris and personal property from the property, okay? But, I don't know if, they're required to dust it, like on a rental, we tell our tenants, you got to leave it in broom clean condition, right? So, but, when you sell a property, you just got to get all the trash out, okay? All right, everybody good with that so far? Any questions on any of that? No, okay. All right, so let's go into A. And I do want to, we're going to talk about that request for repairs in just a second here, because that's going to be a big item. So A, I'm going to look at seller shall within the time specified in paragraph 14A. So that's going to be next week, I think. We're going to talk about 14A. So that's time periods. So seller shall within the time period, and here it is in caps, and we know that when it's in caps, it's important, disclose material facts and defects affecting the property, okay? So that's the seller's obligation. The seller has an obligation to let the buyer know of things that they know about, all right? Okay, including known insurance claims within the past 5 years, right? So that'd be like my clue database, stuff like that. So if there is a claim within the last 5 years, the seller would be aware of it, then the seller would disclose that to the buyer. Now, what happens in my case of a flipper? So my flipper bought the property 3 months ago, they put in new toilets or something, and now they're selling it, for whatever, usually for more money than they paid for it, right? So now do they have an obligation to disclose any known insurance claims within the past 5 years? Well, they can only disclose what they know. So if they weren't told anything by the previous seller, they don't know 5 years back. But if they were told, yeah, then they got to tell. Okay, so if you were told and there's some kind of a document, like you got a copy of something from the previous seller that said that there was, an insurance claim, then you would want to make sure that you are also getting that information over to this buyer. So one of the things that we do is if we have a situation where somebody bought a property within the last 5 years, we hang on to that transfer disclosure statement, and that's now going to be included. And Seraphine, I know you're here today, and I know that we've done that, right? On the property on Colwood, we took the TDS that the buyer received at the time that they bought the property. Now they're the seller. We bring that TDS in, and we have the buyer now of the new property signing off on that as well. Okay. So, we want to make sure that we do disclose everything that we know. If you're going to get tagged on something, it's always going to be failure to disclose something. That's the biggest thing. Okay. All right. Everybody good with that so far? So known insurance claims within the past 5 years. So now some people will say, well, the buyer can find that out. The buyer just contacts their insurance company. And remember, insurance is not a contingency of the transaction. So they want to do that early in the transaction, but the buyer can contact their insurance company who's going to run the clue report, right? They're going to do that to protect themselves, and that clue report might show something that of an insurance claim against the property, something that had been recorded, and that's going to be helpful to everybody. But the buyer that just bought the property 3 months ago and is now the seller may not know what those things are. So yeah, I agree with you. We've got to be doing, everybody's got to be doing their due diligence, but we don't want to, the buyer pays cash and then somehow they feel like they don't need insurance, and then so they never ran that, and so we might have a problem. Okay, all right. So we want to make sure that we do that. But the key ingredient to this is what's in caps, and that is disclose known material facts and defects. So again, material. What does material mean? I don't know. The law says, there's that term of law called the reasonable man standard. And so the reasonable man standard says that that it would be something that would be reasonable, something that somebody would find to be, the reasonable man, so to speak, would find to be important. And again, I love the way the law does that, because then what that does is it leaves it open for somebody else, the trier of fact, to make the decision on what is reasonable. And so, it's like this, right? It's like balancing balls. And it's like, thanks a lot. You really didn't give me any help. Time of essence, what does that mean? Okay. Things like that. Okay. So everybody good with that? We do need to disclose, the seller needs to disclose what they knew or should have known. That is the standard of care for the seller. Any material facts and defects affecting the property. Okay. And then of course we lump in the insurance claims. Okay. And make any and all other disclosures as are required by law. Okay. All right, let's talk about number B. Buyer has the right to conduct buyer investigations. So, this is the one that I find interesting, because I see contingencies, I see attempts to make a contingency in the contract, usually under paragraph number 7A, 2, and 3, where agents will add things in there because there's stuff that's missing that they just can't figure out where it is, right? Well, here's where it is. It's right here. It's in the contract. It says buyer has the right to conduct investigations of the property, okay? And that's the law says that. The buyer has the right, and as specified in 14B, so remember 14A is seller's duty to disclose time periods, 7 days usually. 14B is the buyer's 17 days in which to do their due diligence, right? And of course, we're assuming the seller's going to get them everything within 7 days. Based upon information discovered in those investigations, they can do a couple of things, all right? So what can they do? So one, they can cancel the agreement. So again, it has to be a material fact. All right, so it has to be something significant. Buyer orders a physical inspection. The inspector goes around. He finds, a bunch of lights aren't working. He determines that it's an electrical problem versus a light bulb problem. Well, that might be a material fact, right? But it may be an incidental situation. So if it is just light bulbs, that's going to be a losing proposition, right? So in other words, we'll replace the light bulbs. Buyer's going to try to get out of the deal based on the light bulbs, and it's like, you're not going to be able to do that. But if it's an electrical problem, they don't necessarily have to take the property that. So there's no such thing as a perfect property, but at the same time, this is the reason why we like to disclose all this stuff up front. Remember in our class yesterday on the residential listing agreement, we talked about getting, and we did how to create a winning listing presentation. Get all the disclosures, get them all over to the buyer at the time of the offer, and the buyer can't come back later on and say, well, I didn't know they had an electrical problem. We told you about that. Okay, all right. So again, things that the seller knows. Now, I disagree on some things that people have wanted in our purchase agreement, where we've authorized, or listing agreement where we've authorized the listing broker to order inspections on behalf of the seller. I kind of have a problem with that, because I think that the seller only has to disclose what they knew or should have known, rather than now investigating other things that they're going to add to things that they know. If they didn't know it, they didn't know it, right? So why would they do that? So that's my problem. Okay, so they can do what? Buyer can do one or two things. They can either cancel the agreement, or they can request that the seller make repairs or take other action. Okay, so make repairs, stop doing something that they're doing, or continue doing something that they're doing that they like, that kind of thing. So So let's take a look at what that looks like. So the first and foremost, the buyer has the right to conduct investigations. And so I want to remember that, because a lot of times, there's some agents out there say, no, you're buying the property as is. And it's like, no, I'm sorry. Yeah, we're buying it as is, which means the seller is saying that they're not going to do any repairs. But unfortunately, some people are thinking that it means that, figure it out yourself. Buyer can still do their investigation. In fact, if they don't do their investigation, I would recommend that you get them to sign a waiver that you have told them of their right to do an investigation. And SDAR has a really good form, the Buyer's Election of Inspections form, which I love that form. The state tried to copy it. Theirs is 1 page, ours is 4. And I kind of like the San Diego form. Here's a whole bunch of different types of investigations that you as the buyer can do. And our advice is that you do them. So remember, those are included in your Zip Forms program under the SDAR Risk Management Library. And if you don't have that library, dial in over here. I'll help you get it, okay? But it's pretty important that you have that. It is, the forms that are in there are the standard of practice and the standard of care in San Diego County, okay? So, all right, so let's go ahead. I want to show you the request for repair form, because I have people that say, well, where's that part about, termite inspections? And so, stuff like that, what happened to that? And so when people can't find those things, then they get a little bit crazy, and they want to, they want to make them up as they go. So now I get 7A2 in the purchase offer that says, what are they doing here? Okay, 7A2 in the purchase agreement says, that they're that the buyer, the seller to pay for Section 1 clearance. Well, I just always got a kick out of that, because and they have a really good Q&A on the CAR website, because here the attorneys for years were trying to get rid of that form because it was getting us sued. One of the reasons is that we didn't know what it really said, but then when it disappeared and the form went away, real estate agents who remembered that there was something out there like that said, well, you know what, why don't I just go ahead and add it into the contract again? Okay, so creates a lot of little problems. Like, one of the problems is, now that you put it in the contract again, now the lender's going to require a clearance. And so you just shot yourself in the foot, because the seller doesn't have to do any of those repairs. But when you put in there seller to provide Section 1 clearance, now you're saying that the seller is going to write a blank check at the time of the offer, not knowing what that's going to look like later. So if you want me to send you that Q&A, send me an email. I'm more than happy to send it to you. It's just, they really did a good job on that. And my hat's off to Kathy Maringer. She's on our risk management committee here at San Diego Association, and she was instrumental. In fact, she did the speech on why we got rid of it. Okay, so why we got rid of that form. I've been trying to get rid of that form for years. I just thought it was a real problem for us. And so, it takes a little while sometimes for progress. So here is my request for repair. But I do want to show you one other thing. I want to show you that CAR actually has an as-is Q&A. So here it is, use of an as-is clause. So are the CAR purchase agreements as-is contracts? And so I thought this was pretty well written. And it's not incredibly lengthy. It is a good read. And it's all the stuff I'm telling you right now, okay? Because this is all the legal stuff, but this is all the stuff I'm telling you right now. So if you want, I'll send this to you as well, but just be advised that there's a really good Q&A on some of the things that I'm telling you right here. Let's take a look at my request for repair. So in my request for repair, I've got a couple of things that I'm going to do. Number one, I'm going to have which repair number. Now, I had litigation where the agent did not fill in which repair number. The problem with that was there were more than one request for repairs, and then nobody knew which one came first. Okay, because remember, you don't tack on with the request for repair. If the request for repair fails, then you have to submit a whole new request for repairs. And so then you had a second request for repairs, and that was not numbered either. And now we don't know which one we're working off of. Okay, all right. So important, put in the number if it's number 1, number 2, number 3. So this is the request for repair by the buyer. It is the CAR form RR. I recommend it. I think it's pretty well written, and I'm going to show you a couple things in here about why I think it's a good form. Okay, so first of all, I've got my date prepared just like you have in your contract. All of this up here, the recitals, just like you have in your purchase offer, because this creates my linking between this form and the contract. Okay, so by default it says terms and conditions of the purchase agreement. Okay, dated such. And so that's going to link this document with the purchase agreement, okay? Now later on when we see the response, we'll see the response. You're going to either link it to the purchase agreement or to this request for repair. Either way, 6 of this, half dozen of the other thing. So buyer's request. So let's take a look at the buyer's request. And now we're going to check all that applies, okay? Let me get my little highlighter going here. So we're going to check all that applies, all right? So buyer request, check all that apply. Note, seller has no obligation to respond. So what have I told you before? No response is a response too. If the seller doesn't respond and you're pretty clear that the seller has received the request and the seller chooses not to respond, then that means no. Okay, so when the seller does, and we have it happen, you know, there's a lot of arrogance out there, you know, in a really hot seller's market, you know, we got sellers that say, we're not going to do anything, I'm not going to fix anything. Be really careful. I talked about a really good litigation last week that I had with one of the way this is handled with an assistant in an office. So seller has no obligation to respond to the buyer's request. So we're letting the buyer know that. And the first thing, paragraph number 1A, buyer requests that the seller, prior to final verification conditions, so before the final walkthrough, repair or take the other specified action for each item listed below. Okay, and so my advice when I'm filling out this form, I would do number 1, number 2, number 3, number 4. Make sure you itemize them. That makes it easier for the response. You know, we like the response that says, yeah, we'll do everything, but you know, if they're going to respond with, you know, we'll do number 1 and 3, then you know, we don't know what 1 and 3 are if you don't put that in there. Okay, so you would check the box. You want to check the box. I've seen stupidity about whether or not whoops, we forgot to check the box. You know, does that mean that the rest of it that you wrote doesn't apply? And the answer is, yeah, I think it does. It means the rest of it applies. Okay, so you're going to create a list here, or you're going to attach a list. I would recommend that you have the buyer create their own list, and then you submit that. But that's just how we do it. We like to have that. Check with your broker. Have your broker tell you, you know, what it is, how they like to have that handled. But we like the buyer making the request because, you know, I mean, this form says it's signed by the buyer only. So, you know, in the part of the request, the agent doesn't sign it, but we want it to look like at least it was something that the buyer wanted. Now, I've seen people put, you know, everything in physical inspection report dated, and you know, I think that's just too nebulous. And so, you know, it's kind of like writing a really, really low offer. You're just asking for either no response, or you're asking for maybe a response that says not doing anything. Okay, so that's just me, but I like the request for repair form. So let's take a look. I'm going to drop it down here just a little bit. Carve that out there, not that there. Let's take a look. So we were looking at oops, a little too far. I want you to see A. So I'm looking at my A, and I can also add B. Oops, question. I can also add B, and I'll let's take a look at what. There is a distracted noise in the background. Maybe you need to mute them. What noise are you hearing? Jay, what noise are you hearing? I'm hearing a clicking. Might be my desk. Are you still hearing it? Okay, sorry about that. All right. Nobody else is mic'd. So, okay. Section number 1, we all were familiar with section number 1. We know what that means. Section number 1 means, you know, that we have evidence, you know, prepared by such and such a company, active infestation, active wood destroying fungus, you know, whatever it is, a section 1 item. So when we're looking for that part that's, you know, where is it? Where's the form that says the seller to do all this work? Well, here it is. It's in this form. So this is where if you're going to make a request to have the seller do pest control work, not termites, different issue, pest control work, then you would do it in here. You would check the box, section number 1. Buyer requests seller to have section 1 work completed as specified in the attached pest control. See, I like dating and naming the form. Okay, so in here, I'm going to put in a date, and over here, I'm going to put in the name of the company. Everybody follow me? I like that. We got to reference what it is that we're talking about. Okay, so section 1, we all remember from, you know, those of us have been around the old days, you know, back half a dozen years ago when this was kind of a normal thing. We'd have the seller do section 1, the buyer do section 2, right? Section number 2 says, you know, there's evidence that could potentially lead something to be a problem, but it isn't currently a problem. And in most cases, the buyer just assumed to have that done. So what is the advantage of doing it in the request for repair rather than doing it in the purchase agreement? Well, the advantage is if you put it in the purchase agreement, now the lender is going to require a clearance. So if we do it to handle it the way way that we have to handle it, which is no obligation by the seller to do repairs. But if the seller agrees to do it contractually, then here we need to create that contractual amendment that says now the seller is going to agree to do the work now that they know what it is. Okay, so there were a lot of reasons for doing this, and I frankly, I like the way that it played out. Okay, so this is what I see. I think the fact that we've done it this way, I think I'm seeing a little more professionalism in our industry. And this is the way you're going to handle it. You're going to handle it in the request for repair. When you put it in the original contract, again, the problem is lender's going to want a clearance. And number two, now you're obligating the seller to doing work on stuff they don't even know what it is yet. Okay. And so, and I see that poorly written. I see people, seller to pay for pest inspection report. And then, but it doesn't address who's going to do the work. And so, that's why you got to handle it in a request repair when the seller can look at it and say, oh, it's $1,625. Okay, I'll do it. Right. But, when I had a case, I actually had a listing that I had, and the owner was an attorney. In fact, one of my attorneys, and back in the day when we did that WPA form, and boom, he agrees to do the termite or pest control work. Boom, it comes back $15,000. Gets me on the phone and says, "Get me out of the contract now." Click. Not good. When the lawyer hangs up on you, that's usually not a good thing. It means they're pretty serious. They're not doing $15,000 worth of work. The house was $275,000, and he'd inherited it. He just wanted to get rid of it. And so he said, what did you get me into that mess for? And so I got him out of it. I actually got the work. I actually worked with the pest company to work on their invoice. At the same time, I had, the seller had other work done, and the total was like $1,200 versus $15,000. So let's not get our sellers committing to do stuff that they don't know what it is yet. It gets us into litigation, I guarantee it, and it's ugly. Okay, and we end up paying the bill for that. So section 2, if you want to fill that in, fine. Part number 3 down here, if the buyer requests either of the above, seller shall no later than 5 days or whatever you put in there prior to closing, deliver to the buyer a written pest control certification showing the corrective work. So 5 days ahead of time, much like my final walkthrough, 5 days ahead of time that everything has been completed. Okay, everybody good with that? I thought I saw maybe a question. Let me see, what does that look like? Number 3, on the listing side, hi. On the listing side, would you recommend indicating on the confidential section on the MLS seller will not do any repairs up front so it's clear for buyer's agents? And that's actually a good question, but I probably wouldn't. And first of all, because it shows inflexibility. And again, I'm a practitioner like you, so I'm just telling you, I like putting deals together. But the assumption is they don't have to do any work. The law says that. And if you put that in the listing, if you put, make sure that if you're going to put that in the MLS, that it is also in your listing agreement. And again, I probably wouldn't. And the reason that I wouldn't do it is because it shows inflexibility on the part of the seller. Everybody knows the sales of real property in California are in their present as is condition. Okay, no obligation by the seller to do any repairs. But when you keep calling it out, then people are going to start to feel, okay, what is the seller afraid of? What don't they want? What do they know about the property they don't want to do? And then you just create all kinds of stuff. Let them do their investigation. Remember, you do an inspection. The buyer does an investigation. Okay, and then let them come up with stuff. So the answer to that is I probably wouldn't. But I see all kinds of stuff in listing agreements, and I just go, really? Okay, yeah, I'm not going to do it. So, all right. Number C down here, we're going to get into this. So buyer requests that seller credit the buyer. I personally like credits, okay? And the reason is because credit hides a lot of evil. If your seller agrees, and I had this happen, the seller agrees to do, to fix a spot on the wall on the outside of the mobile home, for example, and says, okay, I'll go ahead and take care of that. And then they go in and they start doing the work, and then boy, the hole just gets bigger and bigger and bigger, right? And then eventually we've got this huge hole because they keep finding more and more stuff, most of which was not important to the buyer because the buyer was going to remodel the place anyway. But the problem that resulted was the fact that the seller started into the work and then just started discovering things, and it just kind of got legs, as we say. It just kind of got its own little life form going on. So I do like credits, figure out what it's going to cost to do the work that the inspector comes up with, and then see if everybody's okay with that. We just closed a transaction where the seller credited, at the time of the inspection, $20,000. Buyer was tickled to death. I have no idea. We were the listing agent. I have no idea whatever ever happened with the property, but the seller told them everything that they knew. They had a physical inspection, got all that. They hired their own inspector to do all that. We didn't even tell them who to hire, and they went ahead and did their own inspection, and that's what they came up with. And so 20 grand, sure, here's a check. Okay. All right, so I like a credit. Remember, we're going to talk about the difference in credit. So we're going to talk about whether or not remember we had that little thing called a contractual credit, okay? And this falls under contractual credit. And then we have the lender credit. And the lender allowable credit was the limit as to how much money the lender was going to allow in a credit. Because remember, if you give a higher credit than the lender's going to allow, the lender's starting to think that maybe you're helping the buyer with their down payment. And so that's why we have those two terms in our purchase agreement. One is my contractual credit, one is my lender allowable credit, and the contractual credit cannot exceed the lender allowable credit. And that's kind of what this says right here. Shall not reduce or supersede any other credit in the agreement unless specifically agreed. So this will be a new credit, okay? Addendum attached if you need one. Credits need to be disclosed to the buyer's lender. You do need to do that. Let's be honest. Don't lie to your lender, just like you don't lie to your lawyer. Don't lie to your lender, okay? Because if you lie to the lender and they find stuff out, now you're in that little thing called a conspiracy, and you don't want to be there, okay? So credits need to be disclosed to the lender, and total contractual credits may be limited pursuant to the agreement. Total credit amount may not be enough to remedy all defects or repairs. It may not be. But again, I've had it happen so many times where the repair work that the buyer wanted to have done, they were going to replace everything there anyway. So why not just give them a credit, let them go ahead and replace it? Because otherwise I'm putting in the bottom of the line, no pun intended, toilet, but they might want something that's, remote controlled or something like that. I don't know. Okay. All right. I'm sure that'll come back to me, a remote controlled toilet. Okay. All right. Or what do we call them? A biffy. Okay. All right. So anonymous, I hope I answered your question. And then finally, D says, buyer requests that seller reduce the price, which, I just think they thought of almost everything. I don't have anything else to add to it, but, price reduction, cool. Okay. Here's the issue with the price reduction. Price reduction works really well in cash offers. But when you reduce the price in an offer where they're getting financing, then you're really only reducing the loan amount and then maybe a small portion of the required down payment on the property. So it works better on cash, but okay, whatever works for you and your client. Everybody good with that so far? Okay, so I'm gonna erase that. And then I'm going to move us down just a little bit because I want to cover some more of this. So then I have paragraph number 2, which, as I have said before, I really like the concept of putting in the name of the inspection company, the type of report, all those things. So I'm just gonna go ahead. I'm gonna check this box, and I'm gonna put the name of the physical inspector, the PI, and then I personally like to put the date of the report in case there's more than one. Okay, that's what I do. You do whatever you want to do, but that's how I handle it. And then I want my buyers to sign all of this. And so the buyer is saying that these are the things I'm asking the seller to do. So let's see what happens after that. So then I go down here into seller's response, and the seller's response, and I've got a couple of them in here. And so you've heard me kind of summarize this before when I've said the seller says I'm going to do everything, the seller says I'm going to do nothing, and the seller says I'm going to do some but not all. Okay, and so those are my 3 options, and here they are. In the first one, the seller agrees, excuse me, seller agrees to all of the buyer's requests provided in writing. See below. 1, buyer removes physical inspection contingency. Not all their contingencies, but just the physical inspection contingency. Buyer removes those contingencies identified on the attached CAR form RR, which must be signed by the buyer. So when the seller responds, they provide that contingency removal, the CR form, along with this form signed for the buyer to sign it, okay? Because that's your job. And I always recommend that you do that but you don't want to rely necessarily on the other agent to do it because they might not have gotten the whole message. Okay. All right. And then finally, number little I, buyer releases the seller and the brokers from any loss, liability, expense claim, or cause of action regarding the disclosed condition of the property. The disclosed, keyword, disclosed condition of the property, right? So if there was something that the seller didn't know about, then the seller can't disclose something they don't know about. Just had a case on that a couple months ago. Seller didn't know. Hey, if you don't know, you don't know. How can you disclose something you don't know? And then the buyer says, well, we kind of feel like they should have known. And it's like, okay, prove that they knew it. And they didn't know it, right? They just didn't know it. You got the same information the seller had, right? So that's kind of how that went. Didn't go well for the buyer. Seller does not agree to any of the buyer's requests. So number one, I agree to everything. Number two, I don't agree to do anything. And then number three, and obviously you're only going to check one of these. Number three, seller responds to the buyer's request on the attached form. And so that says, I'm going to do some, but not all, okay? And we're going to take a look at that form here in a second. In fact, I'm going to pull that up right now. So let's take a look at my seller's, I'm still writing, okay. Edit, okay, good. Can you all see that form? I just want to make sure. Okay, it looks like you can. Okay, so here now is my seller's response to the buyer's seller response and buyer reply to the request for repair. Now, again, back on this form, sorry about that, I should have stayed there for a second. Back on this form, if the buyer agrees to everything, we're done. You follow me? If the buyer agrees to everything, we're done. If seller agrees to all the buyer's requests, buyer hereby removes physical inspection contingency and those identified in the CR form, boom, we're released. Okay. So and I think this is poorly written. Sorry, guys. If the seller agrees to all the buyer's requests, then the buyer removes it. But if the seller says, no, I'm not going to do anything, the buyer can still accept it, right? So there's the checkbox that says that. So I had a really ugly situation where the agent called into the office and asked the assistant, non-licensed at the time, whether or not the seller had signed the request for repairs. And that was poorly worded because, yeah, the seller had signed it, and the assistant said, oh, yeah, they signed it. Well, they signed it all right, but they checked the box and said, I'm not doing anything. And so what the agent meant to ask their assistant was, did the seller sign and agree to do all the repairs? But they didn't ask that part. And so it's like, oops, that was really bad. Bad. Cost the agent $55,000 because the agent ended up doing all the repair because they didn't want anybody to find out they'd made a mistake. Simple little thing like that. And then they killed their assistant. No, they didn't kill their assistant. I'm just kidding you. Okay, all right, so let's take a look now at my seller's response and buyer's reply to the request for repair. Number what? I don't know. Number one, okay, remember we had to write that on the first one, so now that's going to line up here as well. So that will be also number one, to request for repair number one, okay? Or if you put in number two, then it implies that it goes back to number one again. I think that's a little poorly written also. So again, my first paragraph up here, these are my recitals again that link this agreement to now what? It's going to link it to the request for repair instead of to the purchase agreement, okay? So I'm creating my chain. Okay, now avoid the temptation when you put in a request for repair, avoid the temptation in saying, well, we'll just do an addendum. No, you need to use this form. And the reason is because these forms link to each other, they talk to each other. When the agent says, well, we're going to agree to everything, the seller, seller says, I'm going to agree to everything except I'm not going to do the hot water heater. And then the agent wants to just, scratch it on the form or write an addendum. No. Please put it in here. Have the seller write in what the seller is going to do. And I'm going to show you why, because it actually makes a lot of sense. So let's take a look. Seller's response to the buyer's requests, okay? So what? Check all that apply. So number one, agrees to all of the requests, because the assumption here is we wouldn't be into this form if the seller had agreed to everything on the previous form, right? So now it says the seller is going to agree to everything the buyer said in number one, except X, right? So now, remember what I said? I'm agree to some but not all. And so this is that scenario right here. Or the seller says, I'll give you a credit. So you asked me to do repairs, and I'm saying I don't want to do repairs. I'm going to give you a credit instead. Or you asked for a credit, and I don't want to give you a credit. I want to reduce the price. Okay? Does that make sense? Isn't that great? I just like the way it all flows. It just seems to work really well. And a lot of times, with like I always say, and I've said this to you before, but the time to read all this stuff is not when you're sitting in front of the client. You should probably take a look at it before you get in front of the client, because then it makes it easier. Because rather than just sitting there going, I don't know. My answer, by the way, if you are in that situation, is I always say, I don't know what it says. Let's read it together. And then that usually can save me if I don't know what the form says. But I haven't had that experience in probably about 40 years. So any credit included, okay, again, same language from the previous form that talks about credits and the reduction, the amounts and things like that, okay? So number 2, seller agrees to the above. Now this is important. Seller's agreement only applies if the buyer what? A, by default, so if you don't check anything after this, removes the physical inspection contingency. So I'm going to do some but not all, only if you agree to remove your contingency. Or, okay, and I don't know why, I'm sorry. Remove the contingency, and then guess again, I want to have that contingency removal form. I'm definitely going to be adding that to my request for repair. It's going to go back to the buyer's agent with the request for repair and the contingency removal form, removing the contingencies the seller wants the buyer to remove pursuant to this agreement, okay? And now I'm remembering I didn't pull that form up for you. I apologize, but that's what that is, the contingency removal form, okay? All right, and then C, and this is an and statement. C releases the seller and the broker from all that happiness. You hold us harmless, you won't sue us, that kind of thing. Okay, everybody good with that so far? Okay, whoops, got a question. Let's see here. If the seller does not answer, does that cancel the contract? So James, that's a really good question. So cancellation of contract is going to be a legal decision. It's going to be up to a judge. But you know what? If the seller doesn't answer, now we're going to go back to whether or not, the argument that the attorneys are going to have is, was the buyer's reason for getting out material. So if the buyer sends back a request for repair, says replace the light bulbs in the second bedroom, I'm going to tell you that's probably going to be a losing argument for cancellation. But if it turns out that, as I said earlier, no response is a response too, and so if there are material requests, there are material facts affecting the value and desirability of the property, right out of Strasburger case, okay? So if there are material facts affecting the value and desirability of the property and the seller didn't respond, no response is no, and so I'm not doing anything, and so the buyer may have the right to cancel, right? So in other words, it has to be material, and so again, that's going to be an argument that the lawyers are going to have, and certainly the judge will be the trier of fact or the arbitrator will ultimately be the decision maker as to whether or not it was material. So James, your questions are it's a law school question. Good question, okay? Really good question. So does that cancel the contract? No. Contract's not going to get canceled anyway unless the buyer sends over cancellation, and then remember they can't unilaterally cancel. They can attempt to cancel, and then the seller can agree to cancel. But if the seller doesn't agree to cancel, then we're going to have lawyers in there anyway. Okay, all right. So James, thank you. Good question. Got another one. Oh, James again. Can the seller cancel the whole deal or just say we'll not do the repairs? Great question, James. So I know you're asking these even though you know the answer, right, buddy? So here's the thing. The seller can say no. The seller, I'm not going to do anything. They can't use that to cancel, okay? Just because the buyer makes a request, and that's a great question. I get that a lot. People say, well, how about, the buyer makes this ridiculous request and the seller says, oh, forget you. I'm not going to do the deal. That's not going to work because the buyer can ask. The seller has no obligation to do anything, no obligation to respond at all. The buyer now has maybe the right to cancel, but the seller doesn't. So usually the seller's right to cancel is based on non-performance on the part of the buyer. But the buyer puts in this request for repair, and then the seller says, I'm not doing anything. Now the buyer can make an executive decision. Do I move forward knowing that the seller's not going to do anything or not? It's the buyer's right to do that. It's not the seller's. So that's actually that's an upper level question, okay? Sorry, I got down a little bit of water. Okay, All right, these hot summer days. Okay, so good, we covered that. Good question. Thank you, James. All right, so now I'm back into my agreement. So we had our seller's response to the buyer's request. I'll do some, but not all. I'll give you a credit. I'll reduce the price. Other, only under the condition that you remove your physical inspection contingency and you sign the and or, you know, if I check the box, and or you sign the enclosed contingency removal, which please remember again to number it. That's very frequently I don't see it numbered. And when you start having a whole bunch of contingency removals, you don't know which one applies. You know, now you're trying to do math. It's like, it's got to be really obvious. You know, you remember that when you're in court, the judge has everything in front of them. The judge is not going to spend their lifetime trying to analyze your transaction. They're going to let the lawyers argue about it. It's going to go back and forth and back and forth. And then ultimately, they're just going to come to a decision. But, you know, you need to be obvious about what you're doing because you don't want to be in court with everybody else. Okay, so let's make sure we do our job. Okay, all right, so I'm going to clear that part, and let's take a look at what the buyer can respond to the seller's response. So now the seller gave their response. Now I've got my buyer's reply to the seller's response. You see how I'm setting up a chain? So the buyer A accepts it. If the buyer accepts it, they just go ahead and sign it. That's all they got to do, okay? Or statement, or B, buyer accepts the response with the following modification. Okay, I agree with your response, except I really, 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 really want you to repair the pool heater, okay? So that would be something that the buyer would put in there, okay? And please check the box. Or C, buyer withdraws the request number 1. Please, again, make sure you fill out the form, and makes out a new request number 2. So in other words, we're not going to keep going. This is going to be the end of it. If the buyer doesn't accept the seller's response, then we're going to scrap it and we're going to start over, get us another request for repair. That's why these numbers, again, become really important. So buyer withdraws the request. I don't like the seller's response. Let me erase part of this here. So, oh shoot, I did it anyway. Darn it. Okay, sorry. So in C, check C, request for repair number 1. Now we're going to do a new request for repair number 2. Better not say 1 because you can't keep tacking on. You need to get rid of it. And this was written very specifically to avoid the confusion that sometimes we create when we start getting involved in haggling over repairs. Okay, everybody good with that? That's kind of a really important point. Okay, let me take a look now. I want to look at number 2. If the buyer accepts the seller's response, 1A, okay, below to, or if the seller agrees below to the buyer's modifications in 1B, okay, remember modifications, okay, then buyer 1 will be deemed to have withdrawn all requests for items that seller has not agreed to. Okay, in other words, I get it. I'm not going to get those things. Okay. 2, hereby removes the physical inspection contingency. 3, hereby removes those contingencies on the attached CR form, which is signed by the buyer, not the agent. And 4, agrees to the release above. So we're not going to rewrite it. It's already up there. Everybody understand what we're doing? If the buyer accepts the seller's response, if 1A applies, then we move on. Okay. And that's what number 2 says. Okay. All right. So I got 2 conditions in there. You've deemed to have withdrawn your request for everything else. It's over. You're not going to come back to it again. You know, again, it could be something that may happen during the transaction. You know, like a whole wall may fall down. You know, material fact affecting value and desirability. Whoops. Duty to disclose. Perhaps a rescission right. You know, I'd probably give the seller the ability to agree to fix it, but the buyer doesn't have to move forward. Okay. All right, everybody got that? And then the buyer signs it, and then the buyer dates it. Please have the buyer date it. Remember, in your forms, you shouldn't be able to apply a date, and that was a comment I made in a Zip Forms meeting to the attorneys. And I said, you know what, we got people putting dates next to buyer signatures and seller signatures. You know, agents are doing it, and you know, it's not the right date. And so that's creating some litigation that we don't need to have. And so I'm pretty sure we've blacked out those dates for you. So only applies, so let's go down here, only applies if the buyer checks 1B. So in the scenario where we have the modification, remember this one, the modification, then the seller gonna have to agree to the modification someplace. So the seller either agrees or the seller does not agree. If the seller does not agree, buyer may submit a new request for repair. And this can keep on going. And so the obvious question is, well, how much time do you have to do all this if the buyer's got 17 days to remove their contingencies? And the answer is you need to have all this done by then. And here's why. Because what happens if the buyer gets to day number 17, and we have this happen. The buyer, the buyer, I don't know, maybe their agent orders the physical inspection on day number 17, and then guess what? Well, we got the inspector coming out. We're not going to get the report for 2 days. The seller has the right to issue the notice to buyer to perform, and if the buyer doesn't perform, the seller has the right to cancel. Right? So seller may have the right to cancel. So that's why it's really important that you get this done early in the transaction. Some people think that strategically it's a good idea to wait until the end. And it's like, I wouldn't do that, right? I mean, let's be good. Let's be good at what we do. Let's be professional, get it done right away. So you got one or two things are going to happen down here. You're either going to have an agreement or you're going to have a rejection. If there's an agreement, it's over. We don't need any more paperwork. If there's a rejection, then you can go ahead and submit a whole new request for repair. The key ingredient is anything that was in the first request or this response is off the table. We start from scratch again. And this was caused because there were so many problems with all these crazy little addendums and stuff. And then nobody ever, the agents weren't writing. This is to protect you. The agents weren't writing in the language that says all that other stuff goes away. We're going to take it off the table. Instead, no, we got you. You didn't remember to remove that. So this is going to be there to protect you. Okay. Everybody okay with that? So I've handled my, request for repair, and then I've handled my seller's response to the request for repair. Okay, everybody good? Questions? Seeing none. Y'all got some good questions in there today, though, I got to tell you. Okay, let me go ahead. I'm going to roll us into the next part of our document. So that was, believe it or not, we're not even done. We're on number 11, but it's going to go pretty fast now. So number 11, buyer is strongly advised. And so I talked about this earlier in my lawsuit avoidance class. Buyer is strongly advised to conduct investigations of the entire property in order to determine its present condition. Seller may not be aware of all defects affecting the property or other factors the buyer considers important. Okay, material to the buyer, but not to the seller. Property improvements may not be built according to code in compliance with current law or have had permits issued. So we're just simply telling the buyer, you need to be checking this stuff out. You can find out if there's permits or not. You can hire a company to go down there and do it. My agent's not going to do that, right? $50, you can have a permit pulled. You can have a permit inspector do that for you. Okay, everybody good? So it's interesting how when we do, when I'm involved in litigation and the buyer comes back with, I didn't do any of the investigations that I had a right to do because I relied on the agents doing, the disclosure and the seller disclosing everything to me. But then, it turns out after closing, of course, because that's when all the lawsuits happen. After closing, of course, I discovered all these other things. Well, if you had done your investigation during the transaction, you would have discovered them and not closed the deal. Their argument is, I didn't know about it because you didn't tell me about it. Well, the seller didn't know about it. So let's not get into that. That's going to be a bad argument. I know people that will take that argument, but I don't know. I probably wouldn't. Okay. All right. Okay. So let's go ahead. We're going to go on to the next questions. No. Okay. So page 2, buyer's investigation of and matters affecting the property. And we're going to spin through this. So let's talk a little bit about that. So remember what I said before? The buyer has the right to investigate the property. A is such a long sentence. Let's take a look at it. Oops. Where's that coming from? Okay. So buyer's acceptance of the condition of and any other matter affecting the property is a contingency of this agreement as specified in this paragraph and again up in paragraph 14B. Remember 14B are my time periods, okay, for the buyer. Buyer side is B, seller side is A, okay? Within the time specified in paragraph 14B1, okay, the buyer shall have the right at the buyer's expense. Remember, it is the buyer's obligation to investigate the property, not the seller's. The buyer investigates. So the seller discloses what they knew or should have known. The buyer investigates, and the agent does a reasonably competent, diligent visual inspection. Those are 3 separate obligations by 3 separate entities in the real estate transaction. Buyer has the right at the buyer's expense, which includes wood destroying pests. But we're going to get to that. So unless otherwise agreed, to conduct inspections, investigations, tests, surveys, you call it anything you want to call it, have a ball. That's what I always say, right? Anything non-invasive, including but not limited to. So, you know, the lawyers wrote that. What? A general physical inspection. Again, my advice, buyer's election of inspection forms from SDAR. They can't, it's going to be really hard for them to come back and say, well, you had me do the physical inspection. You didn't tell me that there were other kinds of inspections out there. And that's what they say. They come back and they say, well, I didn't know that there was a separate inspection for electrical equipment. I didn't know there was a separate manometer reading. I didn't even know what a manometer was. Okay. All right. So general physical inspection. Number 2, an inspection specifically for what? Wood destroying pests and organisms. Okay. And then here is the paragraph for those of you who've been in the business for a long time. Here's that paragraph that we sucked out of 4A and we put it back in here under 12 because it applies to the buyer. Okay. So here it is. And I'm just going to read it. I'm not going to highlight. Any inspection for wood destroying pests by a registered structural pest control company covering the main building, attached structures, may cover detached, shall not include water tests of shower. All this language was in the old contract, does not include roof coverings. If the property is a condominium or common interest, it shall only include the separate interest. So maybe the interior of a condo, depending on how the CC&Rs are written, okay? And any exclusive use areas that are being transferred. So you have a patio that is your exclusive use, okay? And shall not include common areas, shall include a pest control report showing the findings of the company. So in other words, don't send us a request for repair without giving us a copy of that, okay? And it's going to separate it into what we said earlier, section 1 and section 2. We talked about that, okay? And then number 3, inspect for lead-based paint and other lead-based hazards. We want to make sure you know about that. Where am I here? 4, satisfy buyer as to any matter in the buyer's inspection advisory. Remember that form? People ignore that, right? Because it's at the end of the contract. Well, I'm going to tell you, that's got a lot of really cool stuff in there. You should look at that BIA form. And so when the buyer signs off on this contract, they're signing off on the fact that they're satisfying themselves on everything that was in that form. Okay. Review, number 5, because this is statutory, review the registered sex offender database, Megan's law disclosure requirements, and that just says that you have an obligation by law to disclose the existence of the database. You don't necessarily have to go to it. I always recommend that you don't, because otherwise you can be held to have constructive knowledge of everything in the database at the time you went to it. Number 6, confirm the insurability of the buyer and the property, both. So remember, there's 2 things. 1, buyer's insurance, and then 2, the property's insurance. 2 things on the CLUE database. One of them is whether the property has had claims. The other is whether the buyer has had claims, okay? All right, so including the availability and cost of flood and fire insurance. Number 7, review and seek approval of leases that may need to be assumed. So the lease on the photovoltaic tanks up on the roof of the house, things like that. They've got their period of time. 14B1 is going to say how much time they have to do all that. Without the seller's prior written consent, buyer shall neither make nor cause to be made what? I said it earlier, invasive or destructive buyer's investigation. So you're going to start drilling holes in walls and taking walls out, then that's going to be something the seller's not going to be happy about, except for minimally invasive testing required to do the pest control report, okay, or inspections by any governmental building or zoning inspector. So unless required by law. So the buyer is not going to call out San Diego Gas and Electric. Oh, God, we have them do that. They call out San Diego Gas and Electric. San Diego Gas and Electric goes out to the property, looks at the horizontal furnace up in the ceiling and says, hey, that's one of those ceiling furnaces that was recalled and that was made by Consolidated Industries, and so we're going to red tag it. And then the buyer decides not to buy the property, but the seller can't get that tag taken off without doing a couple $1,000s worth of work. We're all going for that. You get it? Also, like I'll have the city's electrical code inspector come out and look at the property, and then they decide the property's not up to code. And guess what? Buyer's going to have a problem. Okay, because if the seller gets into harm's way because the buyer brought out one of these government inspectors, right? One of these people, then, and there's plenty of people that inspect for it. It doesn't have to be the government, right? But they call these people out and shut this thing down. They're going to be on the hook for that. So that's going to be a great lawsuit. I see it happen all the time. Okay, everybody good? Questions? I got Can the seller, do we already answer that one, cancel the whole deal or just say they will not do repairs? They can say, seller still can't cancel at that point. Seller can't cancel because the buyer makes a request for repairs. They can just say, I won't do any repairs, or they can not say anything at all. Buyer then has to make the decision whether or not to move forward. That's the buyer's choice. The seller can't cancel at that point, okay? All right, other questions? Seeing none. Oops, got two more little things to cover here. So, okay. If you got a question, ask me because this is important stuff. Seller shall make the property available for all buyers and investigations. And by the way, that includes you've got a tenant in the property and the tenant's not cooperating. You might be tacking on the amount of time that the buyer has to do their investigations because of the tenant's difficulty maybe in working. I've had sellers be difficult, so it just happens. Buyer shall, one, as specified in paragraph 14B again, remember buyer time periods, complete buyer's investigations and either remove the contingency or cancel this agreement. Okay, and two, so let me stop on that. So I had somebody arguing with me, it was a transaction coordinator arguing with me that that they didn't have to do the request for repairs until the 17th day. That's not what this says. This says complete the investigations and either remove it or cancel. So the buyer could cancel, go for it, but now they're going to start doing requests for repairs. Listen, our seller is going to hit you with a notice to perform because you know what? You're not doing your job. Okay, so please, if you are a real estate agent or whatever, do not give legal advice to your client. Have them consult with an attorney about what they need to be doing in here. And give the seller at no cost, so we used to say gratis and without warranty of condition, complete copies of all reports obtained by the buyer. So if the buyer obtains a report, they have an obligation by contract to give it to the seller. Okay, now remember that if the buyer walks, the buyer leaves the transaction, that may become something that the seller is going to want to pass on to the next buyer. But if the seller doesn't get a copy of that report, they can't pass on something that they don't have. They can always tell the new buyer, buyer number two, they can tell buyer number two that there was a report, but I just don't have it. I don't know what was in it. I don't have a copy of it. Okay, all right. Which obligation shall survive the termination of this agreement? So if the buyer cancels, buyer number one cancels, especially because of information in the report, seller's entitled to that. So the buyer canceling doesn't say you don't have to do it. Now, I've had buyers come up and say, I'm going to cancel because of all this stuff in the report. And then we've responded with, oh, yeah, really? Okay, give us a copy. They go, well, I don't want to give you a copy. Well, you got to give us a copy. It says it right in the contract. Then, of course, there's nothing in the report. And so it's like, you can't use the report to get out of the transaction. And that's a mistake that some people think. Well, I'll do my investigation. I'll use that to get out of the deal. I have some people, you'll hear terms like 17-day free peek. There is no such thing, folks. People think there is. Some of the people have been around a long time that I can cancel a transaction for any reason. I would never tell that to a buyer. I would never tell a buyer I can get your deposit back for any reason. I would never tell that to a buyer. Okay, your deposit is at risk. Never say you're going to lose your deposit. Just say it's at risk. That's going to be between the buyer and the seller, not between you. Okay. All right, let's take a look. Good, okay. Sellers shall have water. I love this. You get out to the property, do your inspection. The gas isn't on, the water's turned off. The inspector essentially is shut down. They can't do their inspection. So the seller agrees to have everything on, but how long do they have to have it on? And through the date of possession made available to the buyer. So, in the old days, the seller would say, well, do your inspections. And once the inspections were done, they'd have all the utilities turned off so they could save 3 days worth of electricity. And the answer is, nope, can't do that. Contract now says you got to leave it on until the possession is transferred to the buyer. Questions about any of that? I do have one more little thing I want to tell you about. So buyer's indemnity and seller's protection for entry upon the property, and this will close us out with this paragraph. So indemnity means that the buyer is going to pay the seller's cost of defense if necessary. Seller's protection for entry. So remember, when you're allowing a buyer to come into the property, the seller is taking risks by doing that. Even showing the property, the seller is taking risks. But frankly, what happens to the seller if the buyer goes into the property or someone the buyer hires goes in, the physical inspector's up on the roof, they fall off the roof, they break their leg, everybody's going for that, right? I mean, so, and it happens. And so we want to cover the possibility that that might happen. So let's talk about that. We're going to talk about that in D. Buyer indemnity, seller protection for entry upon the property. Buyer shall, number one, keep the property free and clear of liens. We don't want any mechanics liens being filed against the property because of something that the buyer didn't pay a contractor to do, if the buyer is being allowed to do things, okay? Number two, repair all damage arising from their investigation. So frankly, remember we talked about minimally invasive destruction, but sometimes some of these people can start doing crazy stuff. Okay, remember, if they're doing more than just minimal stuff for like pest inspections, then you're going to want to get an early occupancy agreement, something signed by the buyer that says that they understand that they're doing more than is normal in a transaction, and you want to protect your seller from them doing that. Number three, indemnify indemnify and hold seller harmless from all resulting liability claims, demands, damages, and costs. Buyers shall carry or require anyone acting on buyer's behalf to carry policies of liability, workers' comp, and other applicable insurance, again, defending and protecting the seller from liability for any injuries to persons or property occurring during any buyer investigations or work done on the property at the buyer's direction prior to close of escrow. I don't know. I have it done in our transactions, but I know a lot of times, agents don't remind the seller that they need to have the buyer get that type of policy. It's not that expensive, but the seller's policy doesn't necessarily cover invitees onto the property, where the seller may not want their policy to be like the default in case something goes wrong. So the buyer needs to get that policy, and I rarely, agents usually just kind of lock up. It's like, no, get the policy, get the buyer to get the policy. And we've required it in transactions where they were going to do more than just a physical inspection. And frankly, now the seller has an argument that they told the buyer to do it and the buyer didn't do it. And now you as the agent may have a problem later because you didn't remind the buyer. And then again, that's going to be an issue for the trier of fact. Remind the buyer that they had an obligation to get that insurance. So here it is buried in paragraph number 12D, but you still have to be aware of it, okay? All right. Seller is advised that certain protections may be afforded the seller by recording a notice of non-responsibility, and that's CAR form NNR for buyer's investigations and work done on the property at the buyer's discretion. Okay, so let's take a look at that form really fast, and then we'll be wrapping it up. So here is my notice of non-responsibility. Again, this is available for you in your zip forms library. I don't know anybody that's ever pulled it up, but here it is. And guess what? You record it. You take it down. Now, who's going to go to all that trouble? Listen, everybody's going to wish they had if something goes wrong, right? So you need to be aware of this. I would look through it, give it to your seller, say, do you want this to apply? And look at all this happy stuff that you got to do in there. You don't give legal advice, you can't. So, at the end of the day, you're just going to give it to the seller and say, I think you need to talk to your attorney about whether or not you want them in there, flushing the pool out or doing, scrubbing the pool before closing. Anytime you give them access to the property that is, other than just, for a quick little look. Okay. All right. So, yes, you could see that one. Okay. So that's going to be my notice of non-responsibility. And then finally, buyer's obligations. Buyer's obligations under this paragraph, again, shall survive the termination of the agreement. So buyer comes back and says, whoa, this is way too much for me, I'm canceling. Yeah, well, you still have an obligation to do all this stuff. So losing case, I think, but again, I don't give legal advice, and you shouldn't either. But, at the end of the day, we need to understand that when we're creating an agreement between parties, we're just kind of in that little area that could be a problem for us. Okay. Thank you so very much. Take care for now.
Need more help? Contact SDAR Member Services at 858-715-8040 or membership@sdar.com.